sentiments that you shouldn't have been issued with a Rule 3.3 notice, but rather you should have been requested to come to the Commission to assist it with its inquiries. And secondly, Minister, you'll see from our application that we do give credit to you for kick-starting the TRC cases during your term of office. And we extend our gratitude to you and your team for taking those steps. We also agree with you that more cases were pursued in your term of office than in any preceding period. However, Minister, there are a number of issues that we want to canvass with you, and that's the purpose of this morning's proceedings. We will try not to detain you for very long. Commissioners, before I proceed, I just want to place a matter on record that I have raised with the Minister's Counsel, Ms. Zikalala, and that is the question of why certain documents that we rely on were not provided to the team representing the Minister. These are various NPA memoranda which we have referred to in our application. Ms. Zikalala confirms that she was not provided with these documents before the Minister testified on the 11th of August. And the documents were in fact subpoenaed by the Commission from the Department of Justice, and they were received on the 23rd of July. The Kalata Group attorneys received a copy on the 24th of July. So this was some 18 days before the Minister testified. And in an email from the head of legal research and investigations, there was an indication that the documents would be uploaded and distributed to all the parties. Now, as far as we know, the documents weren't uploaded to the website, and my team did a check yesterday. They're still not on the website, it seems. And Ms. Zikalala confirms that she was not forwarded the documents at that time. So that we believe placed the Minister at a disadvantage, because he could have dealt with these in his evidence in chief. And it may very well have negated the need for cross-examination had his team been provided with those documents. So, Commissioners, that explains why the Minister did not deal with the documents at that time. And so we wish to place that on record. Minister, now that we have some of these housekeeping matters out the way, we can proceed. You will see from our application that we have provided you with the issues we intend to canvass with you, as well as most of our questions, so that you're not going to be taken by surprise this morning. Let's start. I'm assuming you have the application before you. I'm on page 2, and I'm going to refer you to a title called, or heading called, the Rodriguez case, from paragraph 12 onwards. In your evidence in chief, you referred to the Rodriguez case as a watershed moment. And by now, of course, you'd be familiar with the facts of that case, so we won't need to go into what that case was about. Suffice to say that it was brought by Mr. João Rodriguez for a permanent stay of prosecution. And the issue in question was the long delay in bringing the prosecution against him. And if we look at paragraph 13, we referred to the supplementary affidavit filed by the NPA. Advocate Turi Pretorius SC filed that affidavit on behalf of the NDPP, Commissioners, the supplementary affidavit, which is dated 4 February 2019, is at page 1 of the bundle. And he indicated in that affidavit that essentially the NPA does not deny that the executive branch took political steps to manage the conduct of criminal investigations and prosecutions in respect of the TRC cases. And we have quoted one paragraph, which is at page 7 of the bundle. Now, to be fair to you, what Advocate Pretorius was referring to occurred long before you assumed office. This was primarily what took place between 2003 and 2010. You only became minister towards the end of the filing of pleadings in that matter, but you did assume office before it was heard in court. And we've referred you to certain passages of the judgment. For example, the judgment of the full court. We've quoted paragraph 21 at our paragraph 16, where the full court mentioned that between 2003 and 2017, these crimes were stopped, and they pointed to an executive decision. The court also expressed its dismay at the interference, and it dismissed the NPA's attempt to portray itself as a victim in those circumstances. You're aware, of course, that it went on to the Supreme Court of Appeal. The SCA dismissed the appeal, and we have quoted the passage of paragraph 26 of that judgment, and we've underlined the section that follows. It was during this 14-year period, 2003 to 2017, that the executive adopted a policy position. And we've underlined and bolded this section, conceded by the state parties that the TRC cases would not be prosecuted. And then the SEA says it's perplexed and this is inexplicable. So we note that the state parties, including the Minister of Justice, effectively conceded political interventions had contributed to the delays. So our question to you, Minister, is, did that remain the position of the Ministry of Justice until you stepped down as Minister in June 2024, when you became the Minister of International Relations?
Thank you, Justice. I think for me to be able to answer the question, I will need to give context as I did earlier on. In my earlier submission, as the Council correctly points out, this was before my tenure, and it's correct that I became aware of this judgment just as I came into office. It coincided with my resumption of office, because I think I started in June, and the judgment was also delivered around the same period. So my first task, immediately after I was briefed by the NPA, as I've said, Advocate Macadam and the head of the National Prosecuting Authority, was to support the NPA to be able to prosecute the cases and all that. And that's why I mentioned that the Rodriguez judgment, this matter should be looked in the context of before and after the Rodriguez judgment, particularly the Supreme Court of Appeal judgment. So at this stage, our focus was to support the work of the NPA to prosecute the cases that were in front of them, building systems and institutions. So it was not my position that was taken by the Minister of Justice before me. I was at this stage not even aware that there was such a position. So, hence, my focus was on the support for the prosecution. Thank you, Justice.
Thanks for that clarification, Minister. But you accept that at least at a technical level, given that your predecessor had filed an answering affidavit and did in fact make reference to the political interference, did not contest it. I must apologize, we haven't put up that affidavit in the bundle, but it can be retrieved if necessary. That at a technical level, that was the position of the ministry, which didn't change under your tenureship.
Yeah.
May I object? And I object because on the basis that he mentions the ministry. If Advocate Vani wants to quote what the ministry said in that judgment, I think it is only fair to counterpose what was alleged and the response thereof, and then ask the witness that, and not make assumptions and conclusions from what the minister did or didn't say. He makes the point that I have not put those documents forward, but this is what the minister said. We contest that. So it would be helpful if he would put those documents before this commission so that we have a clear indication of what happened and what did not happen.
Chair, if I might also add to the objection in relation to the question that's been put forward. As Advocate Vani has already indicated, those documents were not put to the witness in the cross-examination bundle that he was asked to address. And the question that he's asking now is not a question that was detailed for which we were asked to consult with the witness.
Yes.
So this is a completely new matter that's being tacked on to the issues that were outlined in the application for cross-examination.
Yes, Mr. Vani.
Well, with respect, Chairperson, it's not a completely new matter. We actually set it out in detail in paragraphs 12 to 20. So it's not a new matter. I have conceded that we didn't put up the minister's affidavit. That was his predecessor, of course. But that affidavit is before the commission. My team is busy retrieving it as we speak. But the fact is that the Minister of Justice did make that affidavit and did not contest the position of the NPA. So the simple question is whether he accepts that at a technical level, the ministry, as in the minister himself, adopted that position.
Chair.
Mr. Vani, how do you expect the minister to respond without looking at that supplementary affidavit?
Commissioner, yes, I accept that we should have put it up, and we will put it up. But perhaps to expedite matters, I'll move on to the next topic.
Yes, thank you, Mr. Vani.
Thank you, Commissioner, Chairperson. All right, let's turn to the next heading, titled Developments while Minister of Justice, and this is from paragraph 21 of the application. And here we rely on documents that unfortunately were not forwarded to the minister's team before his evidence in chief on the 11th of August. But we have put them up in the bundle. And the first document we're going to refer to is the NPA's memorandum from Advocate Batoy, the then NDPP, to the minister, and it's titled Response to Complaint by Foundation of Human Rights, dated 4 June 2019. We attached it, Mark B. It's at page 45 of the bundle. I just want to make sure that you do have a copy of that memo before you.
Yes, I do.
Thank you. So to save time, I'm not going to read this whole memo into the record. That will take too long. I assume that you've had an opportunity to look at it. And as it suggests, this is a response to a letter that had been written about the Foundation for Human Rights. Now, that letter is not identified, or at least the date of the letter is not identified, but we assume it's the letter from the former TRC commissioners that's dated the 5th of February 2019. And that is a letter addressed to the President, I believe copied to the Minister, calling on the President to appoint a commission of inquiry and to apologize to victims who were denied justice. We have attached that letter. It's at Annex C at page 51. But we're not going to go to that letter unless you wish to refresh your memory. That's a summary of what's in the letter. Then turning to the next paragraph. So NDPP Betoy noted in paragraph 2.1 of her memo, and perhaps I'll just quote this paragraph: "It is unfortunately a fact that the PCLU was prevented from fulfilling its mandate in dealing with the TRC cases because of the following series of events." And these are then reflected in bullet form at the bottom of the first page and then at the top of the second page at 46. And these include, from the NPA's perspective, refusals by SAPS and the DSO to investigate the imposition by former Minister of Justice of a moratorium on the investigation of TRC cases pending the special guidelines, the creation of a special amnesty task team, the creation of guidelines, ultimately, the fact that the then Minister of Justice complained that the NDPP was considering instituting prosecutions, and the fact that investigations only commenced in 2010. So you see that NDP Betoy set out, at least at high-level bullet form, the constraints impacting the TRC cases. So do you accept that, at least by this date, and I see you have signed the letter on page 48 on the 11th of July. Do you concede, Minister, by that time you had been given a high-level overview of what had transpired with the TRC cases?
I'm struggling to get the question. I could not hear clearly.
Apologies. So we've taken a high-level look.
Just the question. I heard the rest of the narratives, but I could not understand the question.
Yes. So the question is, do you accept that by the 11th of July, when you signed this letter and made a comment, that you had been informed at a high level of the constraints that had been holding back the TRC cases?
Yes, I do. And you will remember in my evidence in chief that I said one of the first tasks that the NPA did was to brief me by Advocate Makadam and the NDPP about the challenges the NPA TRC unit is facing and the suggestion that they've put forward for us to take the matters further.
Yes, thank you for that. And then if we can turn to the recommendations, essentially NDPP Betoy is saying that we need to wait for judgment in the matter because the court may make its own recommendation. And she then suggests that you communicate with the Office of the President, and she attaches a draft letter. If we can turn to the comments on page 48, there you'll see that your Deputy Minister, Mr. John Jeffrey, makes the following comment. I suggest the FHR, that's the Foundation for Human Rights, and families of victims be engaged on the way forward. And then you comment as well on the 11th of July, 2019, I agree with the suggestion of the Deputy Minister. Now, as far as we know, that those consultations with the Foundation and the families did not take place. Can I ask you why they were not consulted?
Firstly, I also stated in my evidence in chief that there was a process of engagement with the families, which I later delegated to the Deputy Minister. But also in my engagement with the NPA, one of the agreements was that the process must be victim-centric, meaning that the NPA must from time to time engage directly with the families of the victims in how they are taking these matters forward. And I think, I'm not sure if this is the memo that has that aspect on dealing with on engaging directly with the victims of the families. But if this is not the one, I think the subsequent memos that will follow from the NPA does have that aspect where the NPA was now directly engaging with the victims of the families on a number of issues. Not only just the evidence that the families had, but also on the strategy and how the matters can be taken forward. So I think one of the memos may have that. If it's allowed, my team can help me just to check that paragraph in one of, I know I've read it, is there. But with regards to myself, I did testify here that there was a time where we had a meeting with the families of the victims. The person I remember from the Foundation for Human Rights was Ms. Yasmin Suka, where we met with the ANC, the late Deputy Secretary General of the ANC, and also I think it was Ms. Phoebe Potgieter, and also the Deputy Minister was present in that meeting. All the issues related to the TRC were raised by the Foundation for Human Rights, and the two issues I remember vividly that were of huge concern to them was firstly the lack of resources, dedicated resources, which we responded that we are now working on it. We are in engagement with National Treasury and the Department of Public Service and Administration to deal with that, and hopefully soon there will be a solution in that regard. We also stated that we had just come from a period of state capture where the budget of the Department of Justice and that one of the NPA was on the decline. But we have to reprioritize for everything, including for the state capture cases, which included the Commission of Inquiry into the state capture, which needed a lot of resources at the time. And we stated to the families that we will look into the department to reprioritize. And indeed, there was a reprioritization of resources from the National Treasury. There was also that process to get further support staff for the NPA to prosecute. And then the deputy minister, I then delegated him and requested him to take the discussions further with the families. But I also do remember that from time to time, I will engage even at an informal level with the families of the victims. And this happened at the Credit 4, where I also had some kind of engagements with them. And also when there was some ceremony for Timoli in the central Johannesburg police station. So there has been some engagements with the families in this regard, but also at the NPA level, I was also aware that they are engaging with the victims of the families. So I'm not sure when council says the engagements did not happen, whether the expectations was that it was gonna be some kinds of a structured process of engagements between myself and the families. But to the best of my knowledge, there was engagements with the families, and I'm also aware that this also happened with the NPA. Maybe I will stop there.
Thank you, Minister, for the clarification. Yes, I suppose from our perspective, we were talking about engagements around this time, which is mid-2019. And correct me if I'm wrong, but I think at least some of the engagements you're talking about occurred in subsequent years.
Yeah, I'm no longer sure about the dates, but I do remember that there was a clear intentions from our side and also process to engage with the families, which we also, I also delegated to the deputy minister. But I'm no longer, of the dates, I'm not sure whether it was subsequent. You may be correct, because if I remember, the first engagement was, which I had with the families when we had the discussion with the ANC, was during the COVID period, and I think COVID was around 2020. So that may be correct, that it could be subsequent, maybe some 6 months or a year later, but there was a structured engagement directly with the NPA on the process, and that's where I became briefed on the issue of the contest of the families with regards to the decentralization of the TRC unit, that the families were not agreeable that this process must be decentralized. And in my engagements with the NPA, I agreed that it is the best way forward. So there was a process that was already underway with regards to the engagement. Thank you.
Thanks, Minister. Let's move on to the next document, and we deal with that in the application, bottom of page 5 at paragraph 22. You recall that in the first memo.
Which page?
So I'm looking at our application to cross on page 5, paragraph 22. It's the bottom of page 5.
Yeah, no, I see it now.
Yeah, good. So you recall in the memo we just discussed, it was pointed out by NDP Betoy that judgment was still being awaited. And as it turns out, judgment in the full court was handed down on the 3rd of June, which is something that DG Madonsela pointed out as well. And it looks like that then prompted a second letter from the NDPP, which was sent off later the same day, the 4th of June. Commissioners and Minister, this letter is also in the bundle at page 61. And this letter is titled Findings Made Against the National Prosecuting Authority and Other Agencies in the State versus João Rodrigues. So perhaps we can turn to that letter. It's at page 61. It's titled Annex E. And I'm going to read into the record a few of the passages. And let's start at 2.3 at the bottom of paginated page 61. Evidence was presented under oath by members of the NPA to the effect that no investigations had been conducted into TRC cases from 2003 until the end of 2010. Perhaps I will then jump to 2.4 on the next page. In delivering judgment, the court found that there had in fact been external political interference from persons outside the NPA, which the court refrained from identifying. The court also found that there was a dereliction of duty on its part by not bringing this interference into the open. And there the court is referring to the NPA. And you are familiar with the recommendations that the court made. Let's then turn to paragraph 3 under the heading Way Forward. 3.1, the judgment clearly makes extremely serious findings against the NPA and the executive. The material placed before the court by the NPA implicated inter alia the former Minister of Justice, National Commissioner, and senior officials in a number of departments or agencies. Perhaps I'll just pause here. So I want to put it to you, Minister, that this letter also sets out the finding of the court, and that in its view, political interference played a role in holding the TRC cases back. So I want to put it to you that in addition to the previous memo, this memo also placed on your radar why the TRC cases had not been taken forward.
So what is the question, Mr. Vani?
Whether he accepts that this memo also placed on record the reasons behind the slow delivery in the TRC cases.
Mr. Minister?
I thought that's obvious. I mean, it does place on record. I think what I'm reading when I look at the dates of this memo, it's almost similar to the dates of the other one.
Yes, that's correct. That's correct.
Yeah, so I think from my reading is that my memory may be wrong, but this was on the 5th of June. The other one was on the 11th or so of July. So it was indeed placing this, and that actions needs to be taken, and that's why the NDPP was looking into an appointment of a retired judge. Also on our side, there were various options that were being looked into. So it was during a period where the department and the NPA was engaging on how to take this matter forward.
Yes, that's entirely correct, Minister. It appears that Advocate Betoy signed the letter on the 4th of June 2019, so the same day in which the other letter was sent, and it looks like Director General Vusi Madonsela read and signed it on the 5th of June, and then the Deputy Minister on the 17th of June, and then you signed off on the 1st of July. And it appears that this letter was prompted by the by the issuing of judgment on the 3rd of June, which we think explains why the two letters came in quick succession. But let's
and I think this one might have came before we were aware that Mr. Rodriguez wants to appeal the judgment. So the second one maybe was prompted by now Mr. Rodriguez appealing the judgment, because when you look at the second one, it has that paragraph that states that we will have to wait the appeal process. But on this one, the NDPP was suggesting the appointment of a judge to approach the Chief Justice.
Yes, that's correct. And because judgment had just been handed down, it wasn't known at that time whether Mr. Rodriguez was going to appeal or not. And you are correct that Advocate Betoy in paragraph 3.5 says that she has decided that the proper way to deal with this matter is to approach the Chief Justice to appoint a retired judge to investigate the allegations and advise her accordingly. But if I can just take you back to the preceding paragraph, and I'll just read this in the record so we're on the same page. That's paragraph 3.4, the bottom of page 62. She writes, I could invoke internal NPA processes in order to investigate whether in fact there was wrongdoing on the part of any NPA officials. In my view, however, this would not address the high public interest in the matter and the need for utmost objectivity and transparency. In any event, I do not have the mandate to investigate wrongdoing on the part of the then executive and other departments. Did you agree with her conclusion that she wouldn't have the power to investigate outside of the NPA?
On hindsight, no, I will not agree with that, because as you will see from the NPA's, from the memo itself, the first paragraph where it refers to section 41(1) of the National Prosecuting Authority Act, which makes it criminal offense for anyone to obstruct members of the NPA in the execution of their duties. This could be anyone. It could also be a criminal offense for the executive to interfere. So anyone whom the NPA believes or the police believe has interfered with the work of the NPA is clearly prohibited by the NPA Act, but also section 41(1) makes it a criminal offense. So even the president. So there's no one that the NPA could not investigate and prosecute if they believe has violated this section.
Yes, that's absolutely correct. But you'll notice from paragraph 3.5 that she's anticipating an inquiry that would precede any criminal investigation. If you look at that last sentence of hers, if she had gone ahead with the appointment of a retired judge, then she would have waited for the findings. And she says, if in fact any criminality was detected on the basis of the judge's report, the matter could be referred to the police for investigation. So here she's not talking about a criminal investigation. She's looking to have an inquiry to look into the matter and to see whether there is any warrant for criminal investigation and prosecution against anyone. But here we're talking about an inquiry, and she says that her powers are limited in relation to an inquiry. She can only look at what happened within the NPA, and on that score, I think she is correct.
And that's why you will notice that we had no qualms with the NDPP taking the approach that she was taking of approaching the CJA and so forth. The issue was then the empowering statute. But if you also look into the matters at play, all along our understanding was that this is not just an internal NPA inquiry. It's a matter that affects various organs of the state, and the section I have pointed into, which the NPA, in all the memos that came to me, it was preceded by this section in most of them. So all along our understanding from the onset on this was that the NPA is empowered to deal with this matter within its act. And we did, however, look at various options, including the issue of the Commission of Inquiry, of appointing. When the option of the CJ didn't work, we ourselves also looked at the option of appointing a judge from our side in terms of the constitution that empowers me to do so. And in this regard, we engaged former Deputy President Just Mujapilu, who at the end advised and was of the view that it will not be the best way forward in case this matter ends up in the courts and so forth. And that's how that was also abandoned. And we looked at the other options, and that's why I ended up requesting a legal opinion from our state law advisors, which took us back to the section 41(1) of the NPA Act.
Thanks for that clarification, Minister. If I can just draw your attention to what the Deputy Minister, Mr. J. Jeffrey, wrote at the top of page 64. He writes, "I am concerned that even a retired judge will have to be paid." And he then goes on to also recommend engagement with the families, and we've dealt with that. I can just ask you, did you know what he meant by saying that even a retired judge will have to be paid? What was the issue in that regard?
Yeah,
Chair, I'm not certain where this question goes to.
sorry, switch on both microphones, Ms. Bella.
Thank you, Commissioner. I'm not sure where this question goes to, but it seems to be inviting the witness to speculate on a note that was written by the Deputy Minister when the Deputy Minister himself was here to answer that question.
Yes. Well, the minister says he agrees with the views of the Deputy Minister. So the question is legitimate.
Thank you, Chair.
Yes, Mr. Vani, you may rephrase your question.
Yes, in fact, Commissioner, I was going to point that out, and I should add that unfortunately, when the former Deputy Minister testified before this Commission, to the best of my recollection, these documents were not then before the Commission, which certainly is unfortunate. But as the Chair points out, the Minister writes, I agree with the views of the Deputy Minister. So one can assume that the Minister did consider what the Deputy Minister wrote and agreed with him. So, Minister, I don't want to read words into what the Deputy Minister was saying. I'm sure you have a better sense. But it does give the impression that there was a concern that money would have to be found to pay a retired judge. And that was potentially a problem. Is that right?
Yeah, within that realm of speculation, you are correct that, as I have said when I started, that this is a period where we had financial challenges in the department. And not only in the department, the whole of government. There were budget cuts across government. So it was not just impacting the Department of Justice only, but the whole of governments, there were budget cuts. We are from the period of state capture. The budget of the department is declining. The NPA itself, we were discussing how to support them in terms of the budget with National Treasury, and not just for the TRC cases, but for the overall operations of the NPA. One of the most glaring examples which I provided last time I was here was that the NPA, for almost 5 years or so, could not appoint aspirant prosecutors because of the level of financial decline. And we were now assisting them to do so in a long period of time. That's what we were working on. The second one was that they needed resources for their own operational expenses to increase the budget. The third one was the cases that were now coming for justice on the issue of the Zondo Commission of Inquiry, which at a time was beginning to increase at an exponential rate. So it is happening within that context. So, and retired judges, as and when they are requested to work on commission of inquiries, they do it, but there is a bit of a top-up that the department is expected to provide. So it will always be a concern when you have to appoint a retired judge. You have to look whether you have the budget or not. So I think that is what we are dealing with here, but I hope this does not affect the rules of the commission. It is in the realm of speculation, but within my mind and my knowledge, I can confirm that indeed we had financial challenges. As and when we had to appoint, we had to look at whether the budget will support that.
Thank you, Minister. Let's move on. We do make reference on page 7, paragraph 24, to a Justice Portfolio Committee report, which also considers the Rodriguez judgment, and that the families have requested a commission of inquiry. And then we make reference to a statement that you made in an address to Parliament. And we point out the significance of this statement because it's, as far as we're aware, it's the first time that a cabinet minister or government had made any public comment on the interference. And this was on the budget vote debate in the Department of Justice on 16 July 2019. And you state as follows. This is at the top of page 8. Furthermore, we've noted the recent judgment on the Rodriguez matter related to the TRC cases. We assure victims with similar cases that interference with prosecutorial independence of the NPA will not be tolerated. We continue towards a durable and sustainable solution to all TRC cases, including consideration of interest of victims. So I can tell you, Minister, that statement of yours was very welcomed indeed by the families and victim community. It was the kind of statement that they had been waiting for. Can I ask, was this statement made at the request of NDPP Betoy? You recall that in her first letter, she suggested that that you make a public statement. Was this in response to that suggestion?
Chair, could I just ask that the witness is shown
Ms.
exactly where?
Zikalala, each time, both microphones, please.
Yes, apologies. Can I ask that the witness is shown the specific reference that Mr. Vani is referring to from NDPP Batoy? Because that's the premise on which he's being asked to comment on his speech.
Mr. Vani?
Yes, I'm just looking for that suggestion from the NDPP. Okay, I'm just going to ask my team to find it so that we can move on. If they do, then we'll return to this question. Chairperson, we're about to move to the next document. That's the letter from Minister Lamola to the President. But I see it's almost 11 p.m. I'm still going to be, I can't give an accurate estimate, but I would imagine another 30 to 40 minutes
Yes.
With the Minister. Would this be an appropriate time for the tea adjournment?
Yes, we'll take a tea adjournment until 11:15. We are adjourned.
As the Commission pleases. Thank you, Chairperson. Chairperson, we promised to find that reference. It's in the document that's titled Annex E. It's the memo to Minister Lamola from Advocate Troy. And the passage is on page 62 at paragraph 2.5. It reads, finally, the court indicated there must be a public assurance from both the executive and the NPA that the kind of political interference that occurred in these cases will never occur again. Minister, would I be right in saying that your statement to Parliament that we read before tea is this public assurance?
Chair, it appears the Minister is still just seeking the correct reference.
Yeah, and I've seen it. I'm just looking at the date, and I just wanted to go back to the comment in the questions, the possible questions, which is page 8. Yeah. I think I will not remember whether it was on the basis of this request from the NDPP, but it was clear for me that I was already aware of the Rodriguez judgment, that I'm supposed to, or someone in the executive or the president is supposed to make some kind of public assurance to the families. So it's possible that it came from this request of the NDPP, or it was part of what I already had to decide on. Because as part of the budget vote, you receive lots of information that is compressed into the budget vote. But what I can say is that I had to make this assurance because these were ongoing or live matters, the TRC cases. And also, it was also forward-looking to give assurances to the families that we will not interfere with the process that was already underway in dealing with their matters. Because, as I've said, the Rodriguez judgment dealt firstly with the historical account, and the historical part is where we said we are going to wait for the Supreme Court of Appeal judgment. But the part where it needed assurance for the families, we were not going to wait for the Supreme Court of Appeal judgment because the cases were ongoing. So the families needed to be assured.
Thanks for that, Minister. Chairperson, before I proceed, I just want to place on record, before I forget, the evidence leaders have advised us that of these memos, Annex B and E are in fact on the website. We don't know when they were placed on the website. My team pointed out to me that they mislabeled. Annex B is called Memo 7 June 2019. And Annex E is called Memo from Lamola 8 June 2019. So the dates are wrong, and it's not a memo from Lamola, it's a memo from Batoy. So that perhaps explains why we and the minister's team were unable to find them. We have not been able to see or find Annex K on the website. We'll be turning to that annex shortly. All right, let's move on, Minister. I'm on paragraph 26 on page 8, and I believe you're also on page 8. We're now making reference to your letter to the President. It's titled Response to Complaint by Foundation for Human Rights. It's signed, dated 23rd July of 2019. And you've just made reference to the appeal, but just to tie the loose end, you state in the middle paragraph, I agree with the view of the National Director that the judgment in the State versus Rodriguez stay of prosecution case be awaited before responding to the request made by the Foundation. And of course, that request was for a judicial inquiry. Would I be correct in saying that you did have the appeal in mind when you referred to judgment?
Yes, you're correct.
Thank you, Minister. We do make reference to minutes of a Justice Portfolio Committee meeting. That's at paragraph 27, one in September 2019. I'm not going to pose any questions on that. And we also make reference to the NPA annual report of 2019-2020. Now, there is a reference that I'd like your response to. It's the second paragraph that we've quoted. And this annual report is attached at page 80. I'll just read the highlighted section. It's that second paragraph under paragraph 28. It must be emphasized that the primary issue lies with the investigation of these matters, which is a responsibility of the DPCI. Due to the nature of the cases, it is difficult to access all the relevant information needed to make informed decisions. And so my reading of that is that the NPA was placing on record that there was a problem with the investigation of these cases, and that the investigation rested not with them, but with the DPCI. Now, my recollection is that in your evidence in chief, you did make reference to the fact that the NPA were complaining about the standard of investigations. So would I be correct in saying by this time you were now aware of the poor state of investigations of the TRC cases?
Yeah, if I'm correct with my memory, I don't think I complained about the standards of the investigations. I raised the issue that the NPA raised the fact that both in the NPA there was not enough, both in the NPA and the Hawks, there was not enough investigating capacity. And I even said, because of the relay effect, if you have enough prosecutors, you must also have enough investigators. And that's what the NPA requested us to support them for. So we supported the process of the NPA to get more prosecutors, and we also supported them to work with the Hawks to appoint more investigators, which the Hawks did. It was not the quality, it was the number of the capacity. If I put it, hopefully my English is not a fully Shangan one, you may understand what I mean with the capacity. The number of warm bodies.
Yes, no, we understand perfectly. And yes, it wasn't you who made the complaint, it was the NPA. All right, let's turn to the next memorandum we want to refer to. And that's the toy memorandum to you dated 2nd December 2020. And that's at page 81 of the bundle. It's marked Annex K. Now, before we deal with it, I just want to point out to you that this memo, if we turn to the signature page, which is 94, You can see that it is signed by Advocate Batoy, and it's dated 2nd of December 2020. Then you'll also note that it was not signed by the Acting Director General, Ms. Pillay, nor the Deputy Minister, Mr. Jeffrey, nor yourself as Minister of Justice. And if one looks at the front page of the memo, at the top there's handwriting. It says, "Our copy." And then it says, "To Justice." I can't quite make out the word next to justice. And then there's a date underneath. Can't quite make out that date. It might be the 6th or 8th of December 2020. Now that you've had a chance to look at this memo, do you have a recollection of receiving this memo?
Yeah, no, I don't. It was placed before me by my representatives. That's the first time I think I see. I obviously, with some memos, I may not remember them with the time that has lapsed, but some of them, as I was going through them, I can recall, including the information and all. But this one, I really don't have. I don't recall. And I was also struggling to understand because at this stage, we were waiting the Rodriguez judgment, so of the Supreme Court of Appeal. I'm also struggling what would have been, yeah, so I don't recall.
All right, well, I still want to get your perspective on the memo, given that it was addressed to you at that time. In terms of the purpose, we can take a look at paragraph 1 on paginated page 81. The purpose of this memorandum is to brief the Minister on all relevant issues relating to TRC cases arising from questions raised during a virtual meeting on 16 November 2020, dealing with responses to parliamentary questions. So it seems that you and the NDPP had a virtual meeting on 16 November 2020 to deal with responses to parliamentary questions, and that she compiled this memo to assist you in that regard. Does that ring a bell with you?
No, it doesn't. We had a lot of meetings and preparations to respond to parliamentary questions. So I will really not remember the specific one. I don't.
Right, but as you say, you would typically.
Chair, I just wanted to raise an objection on the record. The witness has already indicated that he has no recollection of this memo, and that he, as it was already shown, he hasn't signed it. So I'm not sure whether it's fair to the witness to then put the issues that are raised in a memo to the
Well,
witness.
that has not, Ms. Sigalala, just wait for Mr. Vani to put his questions first before you object.
Yes, Chair. I was raising it in relation to that first paragraph, which the witness has already indicated.
Yes.
But I will raise it in respect of any other
Yeah.
issue that might arise.
Thank you.
Thank you, Chairperson. So, Minister, given that you've said that you would typically have meetings dealing with parliamentary questions, I suppose I want to put it to you that it wouldn't be unusual to have such a meeting, nor would it be unusual for the NDPP, given that the questions relate to the TRC cases, to prepare a memorandum for you.
Yeah, no, it will not be unusual. She from time to time I will answer questions in relation to the NPA. But usually when these such memos come through, as you have seen with the rest of the others, they will be where I've signed, I will have commented to confirm that I've seen it and I've gone through the memo. So it will be unusual that I have not signed and I have not commented on the memo, if it has indeed come through.
Yes. I think that the Commission and the evidence leaders, that we need to make an effort to try and locate whether there are any other copies of this memo available, which potentially includes any comments and signatures from yourself and others. Sadly, we don't have that today. But nonetheless, given that this memo was in fact prepared and signed by the NDPP at that time in response to what was probably a request from your part for a written memo to assist you with parliamentary questions, I do want to put certain questions to you arising from this memo, but I will keep it short.
Yes, Mr. Vani, what would be the import of putting questions arising from a memo that was not received by the witness?
Well, the witness doesn't say with any certainty that he doesn't receive it. He says that he can't.
Yes, he doesn't recall. So what's the import of putting questions around the memo for which evidence has not been placed before us?
Well, the memo, which is before the Commission, is evidence that the NDPP at this time, which is December of 2020, prepared a document for the Minister. That much we know. It's unclear whether the Minister had sight of the document. That much we accept, Chairperson. But given that this is a very detailed document, it's not my intention to take the Minister through the whole document. But given that it is a very detailed document setting out the perspective of the NPA on what happened to the TRC cases, in which the NPA says that the cases were blocked for a protracted period and that responsibility must be taken, we would like to hear the Minister's perspective on that.
On a document that he has no knowledge of, is that fair for the witness?
Well, I don't believe it's unfair. We simply want to hear from the Minister whether, given what the NPA says, whether he agrees with their conclusion that responsibility has to be taken for the protracted period in which the cases were willfully blocked.
No, Mr. Van, I will not allow that line of cross-examination.
As the Chair pleases. All right, let's move on then to the next heading. And Minister, this deals with the action taken by the Craddock for families. And let me draw your attention to the bottom of page 10. That's paragraph 33. And here we point out that the families, after waiting for many years for action in their case, launched an application in July of 2021 to compel the police and NPA to finalize their investigations and take a decision in this case. a copy of the notice of motion is annexed as Annex N. It's at pages 115 to 120 of the bundle. And Minister, you were cited as the second respondent in this matter. Do you accept, Minister, that this was a reasonable step for the Craddock Four families to take in the circumstances?
Yeah.
Chair, can I apologize to intervene. I just wanted to flag that in the cross-examination bundle, all that was given to the minister is the notice of motion. So the underlying papers and what in fact the application concerned is not anything that has been put to the minister. So to
Yes.
answer whether it was reasonable, the minister would only be given the facts or whatever the relief that is being sought in the notice
Yes.
of motion.
Let's wait for the questions, Ms. Sigalala. Mr.
If I can
Vani.
just point out, if I can just point out, Chairperson, that the papers are voluminous, running to several hundred pages, but we did provide a link to an electronic copy of the full papers in footnote 18. So the question, Minister, is, I'm sure you're very familiar with the Craddock Four matter and how old it is, and the fact that by July of 2021, a decision in relation to that case had not yet been taken. So my question is, was that not a reasonable step for the families to take, to approach a court to compel a decision?
If you could point me the page that you are referring to, I've seen in page 11, the page 10, paragraph 33. But,
Yes.
But where you are referring to the fact that you have given me or my legal representative some kind of summary, I don't see the page. Which page is that?
Well, we've pointed out the relief sought, and the relief sought is to finalize the investigations and an order compelling the NPA to take a decision in relation to the underlying papers, which run to hundreds of pages. We provided a link to those papers at footnote 18. But my question is focused on the relief itself, and whether the relief sought by the families in the circumstances was quite reasonable. Do you agree?
No, I will not know, because as I had no sight of the whole document, but also from what I see here, and with my opposition of the matter, it does look like it was just a run of the mill by the state attorney, which they usually do when the matter comes forward to put a notice to oppose. So I don't think we really, because from what I have seen, it doesn't look like I've even disposed to an opposing affidavit to oppose this in a substantial manner, because I was not really, there was no really any substantial relief against me. So I will really struggle to answer the question, whether it was reasonable or not. I think it will be left to the court to decide it.
Yes, I hear what you're coming from, and I accept that the relief was directed against the NPA and SABC. You were cited, though, as an interested party. I can tell you that the NPA did put up a very substantial answering affidavit opposing the relief. But I won't belabor the issue. Let's turn to the next topic, and that's titled Further Requests for a Commission of Inquiry. We've set out the issues on page 11. from page 35. We've already had reference to an earlier letter that the TRC commissioners addressed to the President. That was in 2019. And then in 2021, they again wrote to President Ramaphosa asking for a decision on a commission of inquiry dated 25 March 2021. Commissioners, that's at page 121 to 125 of the bundle. Now, in this letter, they set out why the subject matter of the proposed commission was a matter of great public concern, and attached drafts of terms of reference, and pointed out that the interference cut across multiple government departments. And I just want to read the one passage which we've quoted here into the record. And then I'm going to ask you a question. It is accordingly not sufficient for there to be separate internal or departmental inquiries by the different institutions. Such inquiries will not be able to deliver the full history of the interference as it unfolded over time and over multiple entities. Moreover, such inquiries will not be able to compel the production of testimony and evidence from other departments. In any event, there appears to be considerable resistance to carrying out meaningful investigations at these levels, and it goes without saying that departmental officials could not be investigating themselves or their colleagues. So my question, Minister, is, did this not make out, in your view, a compelling case for a commission of inquiry that would have powers to compel the production of testimony and documentary evidence, and also given the point that the former commissioners make, TRC commissioners, that this wasn't just the work of one department, but it cut across multiple government departments. Can I ask why you were not persuaded by such arguments to recommend a commission of inquiry?
Yeah, as I said when we started, we were dealing with the compendium of options that we had to look into. And the first process, and I said, we looked into, for me, the matter now was, it has the post-Rodrigo's judgment, the Supreme Court of Appeal, and before. And the before was that the NPA and the Hawks were struggling in dealing, because of resources, to prosecute the perpetrators of the apartheid crimes, to bring them to justice. So in my face, this is the first and primary responsibility. As a Minister of Justice, I need to support the NPA to prosecute the apartheid crimes. And that's what I focused on. Had to look for resources which were not there, engage with the National Treasury, engage with DPSA, that this is what the NPA needs. They need human resource, they need money, and they need to prosecute these crimes. And I'm not only responsible for TRC matters. There is a state capture matter, which there was already a commission of inquiry, which was also lots of money at the time, and I think is the most expensive commission of inquiry in this democracy. At the time already, we are looking, I cannot remember exactly how much, but it was now clear that this commission will end up at billion or something. We don't have the money. We don't have the resource. The first and primary complaint of the victims of the families of apartheid, the ANC, all the liberation movements, their first complaint is that there is no prosecution happening. What am I supposed to do? As a Minister of Justice, I must support that there must be prosecution that happens. And I can do that by providing the financial support, the human resource support, which is what I did. And this is before the Rodriguez judgment, Supreme Court of Appeal decision. But in the midst of this, the families and everyone, they are saying, no, we want a commission of inquiry. If you are in my shoes, you have to make your choices at that time. Do I abandon this course of supporting the NPA and the Hawks to prosecute the perpetrators of apartheid crime and shift the resources to a commission of inquiry that is now going to deal with the post-democratic obstruction and prohibition alleged of the prosecution? Any reasonable person in my position, the focus will be the prosecution of the apartheid criminals. And that's what I focused on, and that's what I did. So, and secondly, as I have shown in all the memos from the NPA, the primary introduction is section 41(1) of the NPA Act. We look at all the options. The first option, the NDPP wants to appoint a judge retired through the CJ, and I think there could not be a mechanism to do that, if I remember well. The second one, appoint retired judge by the minister in terms of the provisions in the constitution. And the retired judge says, no, this won't be appropriate in case this matter end up in the courts. I then look for a legal opinion from the state law advisors. And the state law advisors take me back to section 41(1) of the NPA Act. And seated here, I can't see why, if any matter comes in terms of section 41(1) of the NPA Act, all the issues of public interest can be ventilated there.
So
Because
you
it's
made
public, it's open.
in short, Minister, you made a choice and you stand by that choice.
Yes, I made a choice that I need to focus on the support for the prosecution of these matters, and also that this is a matter for the NPA to handle in terms of section 41(1).
Mr. Vani?
Thank you, Chairperson. Minister, I certainly hear what you say, but do you not agree that when there has been a controversial matter such as this one, where several hundred serious cases, murders and kidnappings are not taken forward, that it's one thing to say, well, if the NPA has hard evidence, then they must just simply prosecute under the relevant provisions of the NPA Act. Because oftentimes there may be information or evidence that doesn't necessarily rise to the criminal justice threshold of beyond a reasonable doubt. But given the monumental lapse of or failure of justice, that governments typically seek to hold an inquiry to understand what happened and why, which wouldn't necessarily be uncovered through a criminal prosecution. Do you agree?
No, I don't. I don't see why it could not be uncovered through a prosecution. People must investigate. They must find out. Statements must be taken. And this goes to a court which is public. The inquests themselves, although they were not dealing with the interventions or any form of prohibition, they were also public. Handed by a judge. The information is ventilated in the public domain. I've just seen this morning the inquiry on to Steve Biko. It's public, it's open. So I think it's just a different of opinion on approach. And this could be the question that the commission will have to decide on. Whether the difference of opinion on approach by the families of the victims and the difference of opinion of approach by ourselves means that therefore this matter can be ventilated in the public domain and be handled in a lawful manner. So it was just a difference of opinion on approach on the matter, in my view. And it's not only on this. And it's not only on this, Mr. Vat. It was also on the decentralization of the prosecution. These were the two contentious issues between the NPA, ourselves, and the families, and the issue related to the Commission of Inquiry. And that's why we then divided to say there was a pre-Rodrigo's judgment, Supreme Court of Appeal, and the post.
Let's move on. We make reference to the response of the presidency in a letter to the family's attorneys dated 6 May 2021. You'll see, Minister, it's paragraph 37 at the bottom of page 11. And the letter itself is in the bundle at page 126. And in that letter, the presidency acknowledges receipt of the letter of the former TRC commissioners, advising that the matter has been referred to the Department of Justice for further attention and reply. It is a matter of record that the Department of Justice did not reply to the former commissioners or the families. Now, in your evidence in chief, you've pointed out correctly that under the law, it's only the president who can appoint a commission of inquiry. That is a power you do not enjoy. And you've also pointed out repeatedly that it's the NPA that has the power to prosecute violations of the NPA Act. And we don't dispute that clear interpretation of the law. But it does seem apparent from this letter from the presidency that they do rely on the advice of the Minister of Justice and Department of Justice, and that they require such advice, or at least the president requires such advice before he decides to act. Would you agree?
Yeah, that's correct. That is also in my evidence in chief. It's in the affidavit that indeed before the president appoints a commission of inquiry, there is some role for the Department of Justice to some administrative advisory role. But the decision is that of the president.
And then a few months later, in June of 2021, Weber Wenzel attorneys then address a letter of demand to the president, copied to yourself, placing the president on terms. And that letter is at page 127 to 128 of the bundle. But moving on, you, on the 23rd of June 2021, announce that the NPA will pursue an investigation into the alleged political interference, and that the investigation will be overseen by a retired judge. In that regard, we refer to a New 24 article of the same date. That's at pages 129 to 134 of the bundle. Now, at that time, no details of that proposed inquiry were released. And as far as we're aware, no consultations were held with the former TRC commissioners or the families. Can I ask why you didn't hold those consultations in respect of the request for an inquiry?
Yeah, I think there was at this stage already ongoing engagements with the families that were happening. If you remember, I pointed out that there was some discussions, and I think, if my memory serves me well, this could have been the point where we now appointed the former Deputy Judge President of Gauteng, Judge Mujapila, who then raised the issue that it will not be appropriate after several consultations with him. And yeah, so I think at that time there was some ongoing engagements on the various options that we were looking into, which included the judge, the NPA approaching the Chief Justice for themselves to appoint. So it was an involved process where we were all looking at which one will be the most appropriate platform to take this matter forward. And I think it was after this that I requested a legal opinion from the state law advisors, which brought us back to the section 41(1) of the NPA Act.
Thank you for the clarification. And then just moving on, later that year in November, the former TRC commissioners and family members and various organizations, including the Nelson Mandela Foundation and the Tutu Legacy Foundation, they issue a press statement. And their main concern is that the proposed inquiry would be an internal inquiry. But let's then jump ahead. If I can ask you to turn to the next page, 13, and let's deal with the Nsebeza inquiry. I'll assume that you're there. So on the 14th of January 2023, the NPA issued a press statement. It's titled NPA further enhances efforts to ensure effective handling and prosecution of the TRC cases. And that press statement is in the bundle at page 142. And in this statement, the NPA announced an inquiry by senior counsel that would be in line with the requirements of Rodriguez, and that the council will conduct a thorough assessment and make recommendations, if necessary, to strengthen the NPA's handling of TRC cases. Now, I want to take you through the key findings of the Nsebeza report as we see them, and these extracts, Minister and Commissioners, are in the bundle at pages 143 to 150. But let me just read the key findings that are in the subparagraphs of paragraph 43. Let me put that into the record so that we can discuss further. The Nsebeza report concludes, and of course he made many other findings as well. We see these ones as the relevant ones. The NPA and the PCLE were swayed from their constitutional and statutory duties in relation to the TRC cases. 43.2. The Nsebeza inquiry could not investigate the political interference given the narrow ambit of its terms of reference and its lack of an investigative arm. 43.3. Commission of inquiry is the only sensible way forward in order to get to the bottom of why the TRC cases were never investigated or prosecuted with zeal. 43.4. A commission of inquiry must be established to investigate the extent and rationale behind the political interference and should look into the roles of multiple state entities as well as implicated individuals. And lastly, 43.5. It must be a public inquiry and be empowered to hold hearings and conduct a proper investigation including the exercise of powers of subpoena and search and seizure. So, Minister, can you see that in Sabeza SC in his report is saying that he was unable to investigate the alleged political interference because of his narrow terms of reference, and he didn't have an investigative arm, and he wasn't able to investigate other entities, and that in his view, a commission of inquiry was the only sensible way to go forward on this matter. Would you concede that the Sabeza SC was correct in those conclusions?
No, I will not, because, I mean, the first aspect is that the terms of reference is the NPA, and we supported the process. But it still does not say anything about Section 41(1) of the NPA Act. You know. And in my view, still there was nothing that prevented the NPA to deal with what is in Section 41(1) of the Act. The Act is very clear. So I will not really concede that all this is correct, but it's correct in the context of the terms of reference by Advocate Nsebeza SC. But in terms of the NPA Act, because the NPA still has the duty to deal with what is in Section 41(1).
Thanks, Minister. I didn't really want to return to that debate, but since you've raised it again, I want to put it to you that it's not necessarily one or the other. So, for example, you made reference to the Zondo Commission. It was the backbreaking work of the Zondo Commission that ultimately led to the uncovering of evidence and leads that were then handed over to prosecutors so that they could commence investigations and begin prosecutions. That could very well have been the same process and outcome here.
Yeah, but for you, when you represent the victims' families, you look at it from the victim's perspective. But I look at it with the overall eye, dealing with the victims, with the TRC matters, dealing with the Zondo Commission, dealing with all the inquests, dealing with all the issues that the NPA needs support from. And these are choices I have to make. It's overall, it's not just narrow TRC matters. I deal with it from a policy perspective. With all that, and you are correct, the Zondo Commission was already weighing heavily on the finances of the department at the time. So it had to be weighed in making the decision. But if you want to comment, if you want me to comment about the processes after the Commission of Inquiry, even with the Zondo Commission, you will remember we had to make a lot of amendments, even to support, to enable the support for the NPA work with the Zondo Commission, because the recommendations of the commissions, I believe even these ones, are recommendations. The NPA and the Hawks still needs to go and investigate if there is any criminality that is being recommended. So already there is an act of the NPA, Section 41(1), which says if there is any interference by anyone, the Hawks can investigate, the NPA can prosecute. It's clear, direct, there's no confusion.
Let's move on, or perhaps just to wrap up that section on the Nsebeza report and its recommendations. Would I be correct in saying that you and the government more generally decided not to implement the specific recommendations of the Nsebeze report in relation to the Commission of Inquiry for the reasons you've put up.
Remember, this is the Nsebeze inquiry is the NPA's committee that they appointed in terms of the NPA Act. And the NPA now comes to us with the recommendation. We still have to apply our mind to the Nsebeze report. And I will not interpret it as an intention not to implement. We had to look at all the options in front of us. And one of them options was what the state law advisors had already advised us on. That this matter falls for the NPA in terms of section 41(1) of the NPA Act to act on, to work on. So there are other matters that came through from that matter in terms of the ongoing investigations and so forth, which we still continue to support the implementation.
All right, well, we know that Nsebeze SC handed over his report in June of 2023. It was publicly released in February of 2024. And then if I can turn your attention to the next page, page 14 of the application to cross, we make reference to the fact that you had noted in Parliament that you had considered the recommendations of the Nsebeze report. But to be fair to you, your term as Justice Minister came to an end in May of 2024. Now, after you left, the President was again placed on terms in a letter dated 10 July 2024. That's at page 151 of the bundle. There's no need to go there. Again, the letter was acknowledged in August of 2024, and the President again says he's waiting for a report and advice from the Department of Justice. That's at page 155. And then when nothing further is heard, the families, known as the Kalata Group, eventually in January 2025, they then apply to court. And part of the relief they seek is an order compelling the establishment of a commission of inquiry, and in a partial settlement that is in fact established, as we're all aware, and that is what we are busy with today. So my question is, Minister, would you agree that the families, in the circumstances, that they acted reasonably and with considerable patience and restraint?
Yeah, no, I think they were. I mean, even in our engagements, formally and informally, the families were acting with reasonableness. There will be times where we will be irritated with the comments of particularly Yasmin Suka, but we still took it on the chin. That is part of our job. If I remember one of the meetings, the comments were really, but we understood that it's an emotional issue, it's an emotive issue, and as government we have to take it on our chin and work on the facts and the law, and that's what we focused on.
Indeed. Let's move on to the last few matters, and I'll try to be quick. And these are matters that arise directly from your affidavit. So I'm now looking on page 14 from paragraph 48 onwards. And this deals with the reopening of various inquests, such as that of Neil Agate and Hussein Haffajee. And we're really on record, Minister, acknowledging the constructive role that you played in moving these cases forward and in ensuring that many other cases were opened for investigation. But I do want to point out to you that in relation to the Agate and Haffajee, as well as the Haron inquests that were all reopened while you were Minister of Justice, that in all these cases, the NPA had to be threatened with litigation if they did not take action. And to save time, I'm not going to take you through those letters. They do speak for themselves. We've quoted a passage from one of them at the top of page 15. Commissioners, these letters are at pages 156 to 167. And then once you assumed office on the 29th of July and the 15th of August 2019, the family's lawyers threatened you with an urgent High Court application if you did not instruct the Judge Presidents in the Gauteng and KZN divisions to reopen the inquests. And those letters are pages 168 to 176. So would you agree, Minister, that notwithstanding much better work that was happening in those years, government needed a nudge to get cracking on these cases?
No, I won't agree. Because I made the decision on the basis of the facts and the law. If the facts were not there and the law did not support, even if there was a gun in my head, we would not have proceeded with the inquest. So I will not agree that what we have done, it was on the basis of a gun being put on our heads. We did it because it was the right thing to do so. The facts that were put before me by the NPA for us to open this inquest were convincing. Secondly, they said we have also to be victim-centric, to work with the victims of the families. And the victims of the families making submissions and making inputs, for me, I didn't see it as a nudge. I saw them as participating to see justice for themselves, for their families, and for this country, which is necessary, given the history of where we come from. So it was out of that commitment to see justice happening that I supported and agreed with the submissions of the NPA on these matters. Even if there was no gun or no nudging or anything from the families, I would still have done it.
Yes, and we don't doubt that, Minister. But can you see it from the perspective of the families? So in the cases mentioned, for example, Agate and Haron, there was a delay of around 2 years or more between the representations made by the families for the reopening and the ultimate decision. And from their perspective, that delay, given the circumstances and the fact that witnesses and suspects were dying, were too long in the circumstances.
Yeah, I would not know that. I was not there. I believe my predecessor could answer that question. Maybe Minister Masuta, I think, is the one. But myself, as soon as these matters were put before me, I made a decision. You can see some of it, the memos from the NPA could have maybe taken a month on my desk as I was applying my mind. But within that month period, I made a decision. And I think it's so with all of them. You can check the dates when the memo arrived and the date on which I made the decision. But with regards to my predecessors, I will not know. I think they were here or they will come, they can answer for themselves.
And then the last matter, Minister, deals with the new approach, which you have made reference to a few times, the decentralized approach, and you've also pointed out that the families were in favor of a specialized unit under a special director, perhaps an investigating directorate to really kickstart the cases. Now, I will say I do agree with you that this is a matter of policy and approach, and that the approach of the NPA, DPCI, and your ministry differed with that of the families. So, in fact, I'm not going to ask any questions on this issue because the families were keen to see a specialized approach in a specialized unit, and you agreed with the NPA that the decentralized approach was the better way to go. So, in the interest of time, I won't discuss or debate that issue with you. And so thanks again for taking time out of your schedule. I know that you have many international priorities that are on your plate. So we're grateful for you coming to the Commission today. Chairperson, no further questions.
Thank you, Mr. Vani. Mr. Siminya.
There is no re-examination.
Thank you. Ms. Sigalala. Before you do your re-examination, Ms. Sigalala.
Minister, thank you for your evidence. I just want your views on the investigations and the prosecution of TRC cases. Now, we know that the final TRC report was delivered in 2003. That recommended prosecutions. And by the time you became minister, which was in 2019, 16 years had elapsed. So that's a decade and a half. And from what has been put before us and from what you have said, it's clear that both the investigation and prosecution of TRC cases required dedicated action. But for those 16 years, certainly before you became minister, who should take accountability, in your view, for the non-investigation and the non-prosecution of TRC cases? Let me put it simply. Where should accountability lie?
Yeah, firstly, I think it should be, I should deal with my term and be accountable for my term. And I think my predecessors should deal with their terms and be accountable for their terms.
But the NDPP, Shamila Batoy, gave you the history of these matters and pointed to the fact that there were no investigations or poor quality investigations and a lack of prosecutions. Now, you were the Minister of Justice for 5 years. If that had happened during your tenure, who would you hold accountable for that?
That's why I looked for solutions. That if there was a problem, let's solve it. And solving it was to put resources, both human and financial. So I believe my predecessors should account for their terms. I'm here to account for what I did, and that's what I endeavor to assist the commission with.
And you've been very helpful. So when you say my predecessors should account for what they did, do you extend that beyond just the ministers of justice?
Yes, whoever was responsible, whether it's the NPA, it's the Justice Department, it's issues of finance, because this involve finance, DPSA and all that. They should be able to account.
Okay. Thank you very much.
Ms. Sigalala?
Thank you, Chair. Chair, I have one question, which is really just a clarification for purposes of the record. Minister, if you could go to the cross-examination application at paragraph 415 of that application, I think it's page 3, that paragraph 15.
Page?
I think it's page 3.
Yes.
And at paragraph 15, there's just a matter I want to, for clarification. The paragraph reads, Lamula became Minister of Justice towards the end of the filing of pleadings in Rodriguez, but before the matter was heard in the High Court. Now, it's a matter of record, just if one looks at the judgment. The hearing of the Rodriguez matter was actually on the 28th and the 29th of March. Minister, when did you...
Of what year?
Of 2019.
Yes.
Yes. So, Minister, when did you become the Minister of Justice?
I think it was June 2019.
Correct. Minister, so just in relation to this paragraph, then the clarification, Chair, is that the paragraph is incorrect in that suggestion.
Thank you.
Sigalala, sorry, have you finished?
Yes, that was the one point of clarification just for purposes of the transcript and the
No,
record.
continue. I don't have my notes with me. Do you remember when the first judgment of the Rodriguez case was handed down?
Yes, the judgment was then handed down on the 3rd of June.
Thank you.
Chair, those are questions in re-examination.
Minister, we thank you for having availed yourself to come and give evidence given your hectic schedule before this commission. We truly appreciate it. You are now excused as a witness. Thank you for coming.
Thank you very much, Justice. Thank you very much.
These proceedings are adjourned until tomorrow at 10 o'clock.